In the 70s, computers were increasingly used to process information about people. Information was also shared by an increase in cross-border trade. This offered economic benefits, but also caused concerns about privacy. A need arose for standards that created a balance between the protection of privacy and the facilitation of free trade. The Universal Declaration of Human Rights and the European Convention for the Protection of Human Rights were two starting points. Both treaties recognize that personal rights are not absolute. There must always be a balance between the rights of the individual and the rights and freedom of others, and, for example, public order. The real starting point for privacy legislation were EU resolutions 73/22 and 74/29. This resulted in a first harmonization of the early privacy laws in Europe. These were followed by the OECD Guidelines in 1980. The guidelines contain principles on cross-border data flows and other aspects of data protection that are very similar to the recent GDPR. In 1981, the Council of Europe approved Convention 108. This was the first legally binding international instrument in the field of data protection. It forbade the processing of special personal information, such as racial or political opinions, health, or criminal convictions. In 1995, the Data Protection Directive reharmonized legislation, but also led to new differences. This is mainly because a directive is not directly binding on all European countries. That is why the European Commission worked on the GDPR between 2009 and 2016. This resolution laid down one binding set of rules across the EU. Important changes include better rights for individuals, increased liability, and additional powers for supervisory authorities.